right, who's first up? Let me read the starter. I'm going to call the meeting to order and do a quick roll. I'll just read off the names of the people I see in attendance. Besides myself, Andy Conroy, I am Tom Parkas, our assistant Tammy Maldonado, our board member Marilyn Altman, our board member Daniel Sanchik, our board member and acting chairman last month, Lee Levy. Have I missed anybody? Speak up if I missed you. All right, good. With that, let me just remind people of a few things real quickly. This is a standard message that we read at the beginning of each meeting. Members of the public can call in and listen to a meeting, and we advertise the address at which they can do so, which is at the website norwalkct.org. They will not be able to speak or see any of the meeting participants. Each meeting will use a unique meeting webinar ID. Please find the information using the link above, and that link is again within Norwalk CT.org 1913, and then meeting notices. Members of the public who wish to provide live comments will need to register in advance and use the Zoom meeting platform. All participants will be muted upon entering the meeting. To speak, click the raise your hand indicator, and you will be called on by the host of the meeting during the public comment section. Please find the information using that same link. Members of the public who wish to view the meeting but are not participating can view a live stream on the City of Norwalk YouTube channel. This stream is delayed by approximately 20 seconds. Please find the information using the same link. The meeting recording and minutes will be posted on the City of Norwalk website within 7 days after the meeting. Members of the public who wish to provide public comment are encouraged to submit those via email in advance of the meeting, for those comments to be read into the record. They should be submitted at least 4 hours in advance of the meeting start time to T Maldonado, MALDONADO at norwalkct.org. So I'm going to call the meeting to order and we'll move on. First up is Mr. Levy. Go ahead and read it.
Okay. First item is 22-0519-01 Sedita Family 2 LLC et al. Variance to allow parking within the front setback, section 118-1220J, compact size in lieu of standard size parking spaces, section 1230B, and relief from required backup aisle dimensions, 1230D1, to create 2 off-street parking spaces on a non-conforming lot in B residence zone, property located at 8 Yarmouth Road, District 6, Block 36, Lot 30. Request: the homeowner wishes to install 2 off-street parking spaces on the property where no compliant parking option is available. Background: this home was constructed in 1900. This home was built before zoning regulations were adapted and has several existing nonconformities, including lot area, number of stories, and property line setbacks. The lot is both a through lot and a corner lot with very limited allowed building envelope. Analysis and findings. There is not a compliant location for parking on this property, which is a practical difficulty. The nature of the lot and the year the home was built could be considered zoning hardships for the board to allow installation of the proposed 2 parking spaces. Turn it back to you, Mr. Chairman.
We have somebody representing that particular application. Hi, Liz. Go right ahead.
Good evening, Mr. Chairman, members of the ZBA. My name is Liz Suchy. I'm a partner at Carmody, Torrance, Sandak and Hennessy, 1055 Washington Boulevard in Stamford. Thank you for reading that memo into the record. This is a continuation of a hearing that commenced in May, and we made our case in chief to you at that hearing, so I don't want to belabor the points that were made. The reason it was continued is several of members of this board, including Mr. Levy, asked us to consider and possibly relocate the 2 compact parking spaces that my clients would like to situate on this property so that they have 2 off-street parking spaces, thereby making it a little less congested in the area and giving them the opportunity to park on their lot. In discussions with staff, we took into consideration some of the suggestions that were made. One of the suggestions, I think it was by Mr. Levy, was to create 2 spaces, one on the east side of the property and one on the west, in essence, providing 2 driveways into the site and thereby creating the 2 spaces. I believe Ms. Maldonado spoke to DPW staff, and due to the narrowness of the lot and the DPW requirements of at least 25 feet of space between the midpoint of driveways, that is not an alternative that we could pursue, since we would not be able to get the requisite encroachment permits from the Department of Public Works. I believe that's correct. Ms. Maldonado, is a correct summary of your discussion with DPW?
Yes, that's correct.
So since that was not an option, we then looked at perhaps moving the spaces to the opposite side of the lot instead of on the eastern side as originally proposed. And if, Tammy, if you wouldn't mind, if you could screen share that original proposal, I'll show you that, and then I'll show you what Tammy and I discussed and what is now before you for consideration as an option. Let's see. All right, Tammy, it's up to you to screen share. So while she's doing that, I'll just describe to you what we discussed. Initially, there were 2 spaces, compact spaces on the eastern side of the property. And hopefully, there we go. If you see on the bottom of the bottom right corner of the lot, there's a block area that depicts the 2 parking spaces as originally proposed. There we go. Thank you, Tammy. Appreciate that. And I think those 2 spaces gave some members of this board some concern or question that perhaps there was a better area on the lot where these spaces could be created. We had intended to put the 2 spaces side by side, and then the area on the northwest corner of the lot where some parking takes place today would be returned to lawn, so there would be some green space added to the site. Since this was a proposal that met with some concern, that was why we came up with option number 2. And Tammy, if you could screen share that. Okay, so you have to forgive my inartful way of depicting what is here. But as you'll see, we moved the spaces as proposed from the northeastern corner, which is X'd out, to the northwestern corner. And it would have 2 parking spaces. They could be situated a little further into the lot, since the lot starts to drop off after the front of those spaces, the end of those spaces would be. And there would be some additional space available along Yarmouth Road to install some landscaping similar to what exists today to create a natural vegetative barrier between the sidewalk and these 2 spaces. So this was the option number 2 that we came back to staff with, discussed, and have presented to you this evening as an option for my clients. Many of the members of the Sedita family who've owned this property for many, many years are as our participants tonight. And if you'd like to hear from them, they're certainly available. I do know that one of my clients would like to address you at some point. But this is what we came up with. And we think this is a better solution that gives my client the opportunity to have 2 off-street parking spaces. It's good for them, and it's also good for the neighborhood, in that this is a neighborhood that is very congested. And many of the properties, particularly those that front on Parkview to the south and Foster Place to the north, don't have off-street parking. So they have to search the neighborhood and try to find on-street parking on Yarmouth or Parkview or some of the other roads. So this is, we thought, a graceful way of accommodating their needs and also addressing the concerns that some of you expressed 2 months ago. That's really about it, since I don't think it's necessary to go through the whole explanation of the hardships in the background, and a lot of that was already described to you. But if you have any questions for me or the Sedita family members, we're happy to answer them.
Anybody on the board have a question?
So the possibility of two parallel spaces along Foster Place has been abandoned entirely?
Yes,
Okay.
yes. We can't configure them to meet the other requirements of all other agencies, and this just seems to be the best alternative, given the fact they'd like to get 2 spaces off the street and onto the lot.
Okay.
If possible, would, I don't know if Stephen Sedita has been elevated to participant, but I do know that he would like to speak. If he could be made a participant and address the board, I'd be appreciative. He might be listed in attendees, raising his hand.
It was Stephen, you said?
Yes, I believe so. Yeah, I think he has his hand raised as in the attendee room.
Okay, hang on one second.
Sure.
Bear with me, folks.
Got him.
There we go. Almost.
Is Steve on via phone or is he using his laptop?
I'm on, well, I'm on my iPad. Can you hear me?
We
I
can hear you.
you.
Okay. Well, thanks for taking the time to hear our request. As Liz mentioned, my family has been on Belle Island for over 50 years. We're well aware of the challenges with parking, especially during storms. I think my sister reminded me that during one of the storms, I think that my father's car was submerged down there on Parkview. And so, we'd like to free up a space on the street by using the available space that we have on the back part of the lot. The house, as Liz says, 125 years old. My mother passed away back in 2018, and we decided to keep the house. For the 14 years where she lived there as a widow after my father died. She didn't drive, so it was less of an issue during that time frame because she didn't need to park a car. She was not a driver. She grew up in New York when people, didn't get a license, and she just never did. We've updated the house. We're very respectful of the tradition on Belle Island. We're, committed to maintaining the look and feel of the island. We kept the house. We didn't, knock it down and build a more contemporary house. We kept the original architectural, which is, I think, pretty unique on the island. And so, we'd like to be able to, free up a space on the street and use it when we're there. I think in the last meeting, someone may have made a comment about why an LLC. Well, it was simpler with family members who were going to be owners of the property to use that LLC structure after my mother passed away. And so, we were all there. I was there for the 4th with my daughters and grandkids who, have all experienced 4th of July on Belle Island. So again, this is ours to keep as long as we can afford paying the property taxes and everything else, in that area. But again, very respectful of maintaining the integrity of what Belle Island has been and hopefully what we will continue to see it be as a very family friendly, place, very unique, I think, in a lot of ways. So we'd appreciate your support, for our request. And I'd be happy to answer any questions.
If I may just add one other comment, and in keeping with Mr. Sedita's respectfulness of not only his neighbors who he has spoken to about the plan, he also and his family reached out to the Belle Island Improvement Association to gain their own input with respect to the change that was being proposed where the parking spaces are. I think that goes a long way to exemplify how committed they are to maintaining the neighborhood in the way that it has been, but giving them the flexibility and also taking some of those cars off the road. If you don't have any other questions of me, I have nothing further to add, and unless Diane McGill, one of the Sedita family members, would like to speak, we have nothing further at this point.
I have a question.
Tom, go ahead.
Yeah, so there's no plan to put a canopy over this or make it a little carport. This is it, two free spots with no other amenity.
Yes,
That's correct.
And I'm just gonna ask, and the neighbors are all in favor of this? I don't have that in front of me, so I apologize. I've been away, so.
No, that's fine, Ms. Altman, Commissioner Altman.
Anybody-
We've all been
favor?
notified, and I think there were 2 letters of support that were received from abutting property owners, but none have contacted me with any objection. None have contacted any members of the Sedita family, and I don't think staff has received any letters in objection.
We just received the 2 letters of support from, I can't remember if we read them into the record last time, but one was from Dean Hackohen.
Hackphone.
And then,
What is his address? If it's listed.
he says he's the neighbor, not sure what number he's at.
Okay.
And then we have Bill Timms, who is owner of one of the 2 properties on Foster Lane. Oh, 2 properties, 1 and 3 Foster Lane, and he's in favor as well.
Well, if you have no other questions of us, we'd be happy.
Oh, I'm sorry, I have one question. Is the plan to keep it gravel or to kind of pave it?
I think at this point it'd be to keep it gravel, but the opposite side, as I probably didn't well note on the plan, where we were originally proposing those spaces, that would be turned into some sort of grass. So it wouldn't be gravel across the front, the entirety of the front, just where the parking spaces are on that right side.
Sure.
Thank you. Well, that concludes our presentation.
Is there anybody else? And Tammy, I don't know if you know how to notice somebody raising their hand. Is there anybody else that wants to speak in favor of the application?
There is no one else with a raised hand.
Is there anyone, and keep an eye on the hands, anyone that wants to speak to object to the application?
This is Diane McGill. Can you hear me?
We can, yes.
Okay, I'm sorry. Something happened with my computer. I'm a Sedita. I'm Diane Sedita McGill. And I wanted also to let you know that I met with the chairperson of the beautification committee of Belle Island and brought her up to the house and discussed the spaces and what we would do to make it, aesthetically nice. And she had absolutely no problem with it. And that's all I wanted to say is that we're going to do as much as we can do so that there is no issue. And like I said, she's beautification, so it passed with her.
There are 2 phone call-in listeners. If you would like to speak either for or against, you have to press *9 on your phone to raise hand and then *6 to unmute yourself.
Perhaps not for this matter.
So, not seeing anyone that is opposed, I don't think you have to rebut anything, Liz.
Correct.
So
Thank you.
we'll move forward. Just make sure that we got all the bases covered. Does anyone on the board have any further questions? All right, hearing none. We'll put this up for a vote later in the evening and close this information piece of it.
Thank you very much for your time.
Thank you.
Thank you.
Thank you.
Next item, there's also a continued item from last meeting. Property at 8 and 10 Pulaski Street.
A, item 22-0616-01 BBB Pulaski LLC. Variance to reduce the minimum lot area per dwelling unit from 1650 square feet to 384 square feet to add one dwelling unit, section 118-360C, within an existing building for a total of 16 units, 8 units in each building. Total lot area 25,143 square feet in D residence zone. Property located at 8 and 10 Pulaski Street, District 5, Block 47, Lot 91 and 97. Request. The applicant seeks variance to legalize an additional existing 16th unit. Background. The development was approved by special permit in 1997 for 2 3-story buildings with a combined total of 15 dwelling units. Zoning permit was issued in January 1998 for 15 units. A conditional certificate of zoning compliance was issued in June 1998 for 15 units, 10 2-bedroom and 5 1-bedroom units. Analysis and findings. I cannot identify a zoning hardship for this case. The fact that there is an existing non-conforming number of units should not be the sole justification for granting variance. Should the board grant the relief of the regulations to allow the 16th unit, the applicant will also need commission approval to modify the special permit.
Who's going to speak for the applicant?
Chairman, members of the board.
Well,
Good to
no,
be
don't go ahead. I'm just asking who.
Chris Russo with Russo and Rizzio LLC.
All right. I had another question for Mr. Levy.
Yes,
We continued this for what reason?
I believe the applicant withdrew because we only had 4 commissioners present.
Oh, you did? All right.
Yes.
All right. Go ahead, Mr. Russo.
Chairman, members of the board, Chris Russo with Russo and Rizzio LLC, offices at 10 Sasko Hill Road in Fairfield. Good to be before you tonight. I'm going to share my screen and go through a bit of the history of this property. As was stated, these buildings were approved in 1998, or I'm sorry, 97, and then they were built in 1998. And they're really 2 properties. They're both called, one's 8 Pulaski Street and the other one's 10 Pulaski Street. But in reality, one has frontage on Pulaski Street and the other one has frontage on Sniffen Street. And they are essentially mirror images of each other. The same number of floors. Really the only difference between the 2 of them is that this building along Sniffen Street has a covered parking area. You can kind of see the cars there sticking out. And then a parking area opposite as well. But they're similarly positioned off the street, about 50 feet off the street, both buildings. Basically mirror images of themselves. The builder of that property, we now know, got approved for 15 units, as was stated. He apparently continued to discuss with the city about getting a 16th unit approved. And went back and forth with the city, and he ended up adding the 16th unit in this building over here, the one that's along Sniffen Street, and renting it out. And then when he went to sell it to my client, he was advertising it as a 16 unit building. My client, during the due diligence, we found the approvals in saying that it was actually approved for 15 units and that the 16th unit wasn't legal. And so, you know, we kept looking, because he kept claiming that I think it was, you know, that he had been working on getting it legalized and the city knew, but it was only legalized for 15 units. That's all it had approvals for. So my client closed, bought the property, and stopped renting out the 16th unit. And the breakdown that the original owner had was 10 2-bedrooms and 6 1-bedrooms. So there was 5 2-bedrooms in each building, along with 3 1-bedrooms. So the unit that he had fitted out was a unit on the first floor that faces this backyard. It's pretty small. It's about 500 square feet, a little bit less, and it was 1 bedroom. We haven't we haven't rented out that unit since our purchase of it. And we looked at the regs, and we noticed that, one, we had enough parking on the site for a 16th unit. There's 21 spaces required under the regulations, and we have over 21, with 22. So we had enough spaces for it. And we don't need to build any more floor area or any more building. It's really would just be legalizing this extra unit. As stated, in the D-resident zone, for lots above 6 dwelling units, you need 1,600 square feet of lot area per dwelling unit. And if you divide that into our lot, it comes to 15.23 units. So we have enough for 15, but just not enough for 16 units. Interestingly, under the regulations for elderly housing in the D-resident zone, the requirement's only 1,250 square feet per dwelling, which would allow 20 units on our site. But as this isn't an elderly housing development, it doesn't qualify for that standard. But the city then recently, in May of 2021, passed its latest version of the workforce housing regulations. And here, I'm gonna switch to the site plan just so you can see the site plan. The purpose of the workforce housing regulation is to address the shortage of affordable workforce housing, which is found to be detrimental to public health, safety, and general welfare, and to economic development. And the regulation was meant to encourage such housing units within multifamily developments like ours. And my client looked at the fact that the space is already there, and thought this was really a unique and great opportunity to provide a workforce housing unit and get towards this goal that the city is trying to reach. And so that's where we're here before you tonight, to propose a workforce housing unit within the existing floor area. So we're not changing really anything about the site. We already have enough parking for the unit. The buildings are already built. The space is already there. It's just to legalize this unit as a workforce housing unit. And, you know, frankly, funny enough, we don't think it's going to have any impact on the neighborhood, because it was already rented out as 16 units by the prior owner. This is an area full of multifamily developments. So really nothing's going to change on the site. or for the neighborhood. I mean, it was 16 units. It was being rented out as 16 units. It's now since been gone down to 15 since my client bought it. But really, there's just going to be no perceptible change and impact on the neighborhood. If I could show you, let me see if I do this right here. Some pictures from okay. Not sure. Sorry, I'm trying to share my screen and it's just sharing the individual photos. Sorry about that. Let me see if I can get it to just share the whole screen. I want to run through some pictures of the site with you. Okay, I'm having problems sharing the whole screen, but so this site, it's again, not changing at all. Surrounding it right across the street is a 4-family dwelling. It borders the NB zone to the south. There's a bodega there that has 5 dwelling units. There's a warehouse to the south of it. On the Sniffen Street side, there is another 4-unit multifamily development, and then there's a 7-family multifamily development just a few doors up that runs from Sniffen to Pulaski. And then above that is an industrial area. So we think it fits in with the neighborhood and what's around there. And really, because Norwalk is mostly developed, it's tough to achieve these goals, which the city's trying for 10% workforce housing units in these multifamily developments. It's tough to achieve that without infill development. And this is certainly infill development. It is just placing a unit within an existing building without adding anything. With regard to the granting of a variance, one, there's the issue of the impact on the neighborhood and the character of the surrounding neighborhood, what I just talked about, but also as a separate basis for granting a variance is the reduction or elimination of nonconformities. With this application, if I could share the site plan, we are reducing 2 nonconformities. The first is that there's no recreation area currently on the site. We're proposing, and each dwelling unit should have 200 square feet of recreation area. We're proposing an area right here that you can see for 510 square feet. So double the requirement, or more than double the requirement that would be for a single unit. So we're proposing that there. We also have the ability to put another recreation area over here, so there would be for one for each building. So if the board felt that was appropriate, we would be happy to basically double this recreation area that we're proposing, and thereby reducing the nonconformity that exists on the site now. And then on top of it, the multifamily developments in Norwalk, the goal is for a development of this size that is greater than 10 units for there to be 10% workforce housing units. Right now we have 0%. There's no workforce housing units. With the approval of this application, we will get to 6.25% by adding this workforce housing unit. So we believe that serves, and the reduction of nonconformities can serve as a sole and separate basis for granting variances. It's really a fairly minimal request because, again, no construction, no more floor area, no more building, just to add a 1-bedroom dwelling unit, just 1 bedroom. The reg, it's funny, it says that you have to have 1,650 square feet of lot area per dwelling unit, but it doesn't specify, it doesn't differentiate between bedrooms. And so technically we could have 15 two-bedrooms, which would be a lot more intense than what we're proposing right now, which is 10 two-bedrooms and 5 one-bedrooms. So, you know, we feel that this is a pretty minimal variance, but something that adds a workforce housing unit in really a great location, because this site is only about a 5-minute walk from the bus stop on Main Street that's nearest to it. So it's a really convenient site and location for somebody. I know that regulation targets providing housing to people who work for the city. So it would be very easy for somebody who works for the city to live there, catch the bus, and go to where they need to for the city. So we think it's really a great opportunity to provide that unit, again, for a minimal variance, and this ability to reduce the nonconformities. That's basically it. I'd be happy to answer any questions, but it's pretty straightforward, as there's really nothing, you know, proposed except just creating this unit.
Tammy, if the workforce allowance is less, or requirement is less than that for regular housing, how much less is it, and does it allow us to fit another unit in?
I'm not sure I fully understand the question. I'll give you my answer and then you can tell me if you need me to restate it. So by adding, so when this was approved in the 90s, there was no workforce housing requirement. Probably it didn't meet the threshold. I think back then it might have been 20. I don't remember for sure. And so now by legalizing this 16th unit, that workforce housing amendment that was done a couple of years ago forces this unit to become a workforce housing unit. Does that make sense?
But would we have to grant a variance for the square footage involved or not?
Yeah, so that's what they're seeking to vary. And then they'll have to make, if you grant the variance, you know, to allow the 16th dwelling unit, which, as Chris said, will be an existing, or I guess reconverting a 1-bedroom, I'm not sure. Then they'll actually have to go back to the Planning and Zoning Commission to modify their special permit as well. Then when they obtain, should that be approved, then when they obtain their zoning approval, they're going to have to designate it as a workforce housing unit, which we have a system in place to manage that.
All right. So there is more to do, even if we do grant the variance. I just want to make one note, one comment, and then we'll go to the board for their questions. And that is, every time we get congregate or multifamily housing coming up, I always ask about the recreation areas, because we find owners have managed to slip around the requirements. And I insist that we make sure that requirements are met. So I think we should think about that tonight. Are other questions from other board members?
Very simply, in providing a recreation area, first I'd like to ask how many children are living in this 2-building complex, and what type of recreation are you proposing?
So I am not sure. I do know there are children there. I am not sure as to the exact count. But there are children there. So I talked to my client, and he was looking into a playground swing set, and then also providing some picnic benches. It's actually a pretty nice. Let me go back to the site plan. It's a pretty nice area here where it's blocked, and there's a fence right here, so it is fairly secluded. So he was looking to put picnic benches here and a swing set, and then also looking over here on the same. He actually has started to work on a walkway over here to lead out to an area, and do it also over here. Same thing. It has a fence here, and there's a bunch of plantings over around here in the front of the building, that gives it a nice secluded area. That would be nice if, you know, people were outside grilling or, you know, having friends over, that they could sit out and do it. So we're open to any suggestion that the board has, but the intent is for a swing set for the children, and then picnic tables for the residents to enjoy and be able to eat outside.
Thank you.
And we'd be happy, again, right here on this plan that we've submitted, it shows 510 square feet of recreation area, which is again in excess of the 200 that would be required for this unit. But we would be happy, as a condition of approval, to accept another recreation area over in this corner as well.
Anyone else with a question?
No question. Just to be clear, so this was going back a 520-foot square unit that is now not being rented out. So it's a complete unit, kitchen and everything.
Yeah, it was a complete unit. Yes.
And
Yeah.
I'm just curious, does anybody know or care how many people could rent this? Is it sort of a one family? And I ask because of parking spaces, and also when you say it wouldn't impact anything. So basically it would just be a family with, I don't know. Is there a limit on, or is there any regulation about?
I think as far as number of people, I don't know if there's a limit on a single family. I know there's I think it's a 4 unrelated persons limit, but I mean, for a 500 square foot, I mean, it's pretty small. I would think it would be either a single person or a couple. And the comment I was making about the impact regarding parking, I was just saying there right now, as there is now, there's enough parking spaces for 16 units. We satisfy the requirement of the regulation, which is 1.3 per dwelling unit. We exceed that in our existing parking to conform to the regulations.
So just to clarify, the regulation is no more than 3 unrelated
Oh, okay, sorry.
people within a dwelling unit.
Yeah, other towns like Fairfield, I think it's 4, and there's
Yeah.
other towns, you know, the numbers varies, but yeah.
Anyone
I have,
else with a question?
yeah, I have a question. So 10% of the units would end up of 16 units would end up at 1.6. And I don't know if maybe this is for Tammy, that there's no requirement for when they add this unit to then come into, you know, to add another workforce unit so that there are 2 in the building.
Let me pull up the reg real quick. Can you just give me 1 second? I want to double check it.
Sure.
Yeah, my understanding is because those 15 were approved and existing before the workforce housing regulation, it's only this one that has to become a workforce housing unit. And the way the reg reads, it has to be a workforce housing unit for as long as it's in existence. So in 50 years, if it's still there, it still has to be a workforce housing unit.
Okay.
So it will always be that. If they ever in the future decided to add more units, any additional unit would still have to be a workforce housing unit, because we're still under the 10%. With this if we were to receive approval, we'd be up to 6.25%. So we're closer to the 10%, but not quite there.
Yeah, and just while Tammy's looking it up, I would also ask if there's any other, just because I'm not so familiar with the regulation, if there's any other things that a workforce housing unit requires.
There's a requirement with regards to, and I'm pulling it up too, who you're able to rent it to, the process for renting it to it.
Right.
The first is for you offer it to existing tenants who are displaced, but that doesn't apply in this case because there's nobody being displaced. And then the second is employees of the city of Norwalk and the Norwalk Board of Education. and residents of the city of Norwalk who have resided in the city of Norwalk a minimum of 1 year prior to the issuance of a CO for the unit, and then just generally persons employed by the city of Norwalk. And then after that, there's an income calculation that you use. Basically, it's geared towards individuals with a moderate income. So there's a whole formula you have to follow about who you are able to rent it to.
Okay, I think you're gonna have to provide 10%. It says existing multifamily or mixed-use developments that do not contain designated workforce units and are proposing additional dwelling units shall comply with, and it states section 1015 D1 and D2, which that's, the same section. D2 says all zoning permits for the construction of multifamily or mixed-use developments containing 10 or more units shall designate a minimum of 10% of total number of dwelling units. So I think you're gonna have to provide 10%, but I'm sure the commission will cover that as well. When you apply to, if
When you apply
this
for it.
variance is granted and you apply to modify the special permit.
Sure, and yeah, my understanding was because the 15 were approved as not workforce housing units, that that approval would stand, but this new approval would be the one that requires it. But yeah, again, we have another level to go here, which would be to the commission, and they would be the Planning and Zoning Commission, and they would be the ones that would designate that.
Okay, thanks.
Are there further questions from the board members?
I have nothing further.
Okay, with that in mind, is there anybody that would like to speak in favor of this application? Looking for raised hands.
So no raised hands, but again, I'd have 2 phone call ins. So if you're calling to speak in favor of this application, you have to press *9 to raise your hand and then *6 to unmute yourself.
Let me assume that we're not going to hear from them and ask right away, is there anyone that wants to raise their hand to speak against the application? I take it we're not seeing any hands come up.
No hands.
Okay, so Mr. Russo, I don't think we need you to counter any arguments made because there were none made. With that in mind, I think we're done for now. We've accepted your input. And
Chair-
I'll let you know later after we vote.
And Chairman, if I could just restate real quick, under case law, the zoning board of appeals is allowed to grant variances in an instance where separate from hardship, entirely separate from hardship, where an application reduces nonconformities. And again, on 2 issues. One, on the recreation area, we're not only proposing the 200 square feet that we would need for this unit, but 510 in addition to that, and we'd be willing to accept as a condition of approval, a doubling of that. So to really, further reduce the nonconformity. And then the second being getting closer to this 10% workforce housing units for multifamily developments such as this. So we feel that that is a sufficient basis for this board to grant these variances. And in addition, we feel that we are meeting the intent of the regulations by meeting this demand for workforce housing units that the city is looking for, that the planning and zoning has put this regulation in place to try to promote it. It's just hard in a city that is this developed without infill development to achieve that goal. And so we are trying to do that merely by creating a 1-bedroom dwelling unit in an existing space. So for those
I
reasons,
fully
we-
understand what you're doing.
Yeah.
I believe the board members also fully understand what you're doing. With respect to variances, you mentioned that word in plural. I thought you were only asking for a single variance.
Yes, just one.
All right,
Just for the lot area per dwelling unit.
all right, good. All right, I thought maybe I missed something. So we're going to move on.
Thank you, Chair. Thank you, Board. Appreciate the time.
Bye-bye. Mr. Levy, Next item
Okay.
up.
Next item is
C.
22-0616-04 Leonardo and Natalina Fino.
Alina. Not
Okay.
Alina,
Natalina. Fino variance for number of stories, 3.5 stories proposed, 2.5 stories maximum allowed, section 118-340C, and variance to allow parking within the front yard setback, section 118-1220J, for an existing single-family dwelling in a B residence zone. Property located at 34 Burritt Avenue, District 2, Block 86, Lot 16. Request: the applicant seeks variance to exceed maximum stories allowed, created by excavating without permits, and to allow the parking area created in the front setback to remain. The single-family dwelling was built in 1930. The owner undertook alteration and excavation of the front yard without zoning or building permits. The owner was ordered to stop work by both the building and zoning departments in January of 2021. The property has been in the zoning citation hearing process since last summer, and the property owner now seeks the relief from the Zoning Board of Appeals to cure his zoning violations. Analysis and finding: this is a self-created hardship. The once sloping front lawn is now a large swath of stone, concrete, and gravel. If the board considers granting the relief, a condition of approval could be to restore half of the fill, grading, and landscaping to make similar front yard conditions as the property next door at 32 Burritt Avenue. Mr. Chair, back to you.
I think I may need to make a note of this because I remember seeing an application related to this, but not this particular application some months ago. And I think I discussed it with Lee Levy. And the application was withdrawn and we never saw it before the commission. So it was just paperwork flowing through. So it was similar and we both had thought it odd. And that was the extent of the discussion. But I want the applicant to know that the two of the board members had seen something similar and had discussed it. And who is speaking now for the application?
Mr. Chairman, members of the board, my name is Lucas Thomas, and I'm an attorney with the firm Owen, Shine and Nicola, and I'm representing the applicant. I was retained to hopefully see them through this, and my application itself has a bit of a memorandum attached to it, and I can give you, again, a little bit of a background. The Finos, my clients, they have owned this property since May of 1977, and they are getting up there in age, and they've seen their neighborhood become more and more congested with traffic. There's a boat club or yacht club down the road, and that leaks over out of that parking lot onto their street. And they thought that it would be a good idea, as my clients also has a background in masonry, to get parking, 2 spots of parking off the street onto the front area. And while doing so, they've also put a front door what would have been the foundation wall. So it's opened up an area there so that they can get in easier and be able to get into their home without the numerous stairs that were there prior to that. My clients are seeking a variance on two grounds. One is the height from 3.5 to 2.5. What happened was when they dug it out, obviously it showed the I don't even know how to call it, the front foundation wall, and that now became a full story based on the regulations. It wasn't anything that they built. It was the house that was there since, I think, 1930. And that was one of the items that prompted us to seek a variance. And the second one is clearly getting two cars off the road and onto their property for the purposes of safety. And Norwalk itself has a regulation that touts parking, off-street parking, especially 2 parking spots for a Zone B property to be off-street for the purposes of health and safety. And my clients who are here with me in my conference room, if any members would like to speak to them, I'm more than happy to have them answer any questions that you might have. It's become more and more of an issue for them with the parking and being able to find parking on the street. The way that it's set up, there's only a few spots, and many of the neighbors have complained over the years to the police department about this. But I guess the boat or the yacht club is a bigger client or somebody that the police just say it's a one-time event. There's nothing for us to do. And my clients did take out that front area, believing that they were able to do so and were thinking that they were going to do something good. My argument being that even by doing so, it's a form over a function, if you will, by digging it out, and all of a sudden it's a third story. The tip of the house is still relative to all the other neighbors. And by the way, all the neighbors personally have spoken to my clients and said they love what's happened there. And they're glad that they're doing it to get more stuff, the cars off the road, if you will. The work itself isn't finished. They were ordered to stop, and they did stop, and then they came and hired me, and I brought this. But if you were to look at it, some pictures now, and Tammy, would you be able to put up one of the pictures that you have? Let's start with the 2014 picture. Oh,
All right, sorry, do you mean the ones attached to my staff memo?
yes, yes,
Yeah, just bear with me, it'll be just a minute, okay?
sure.
Mr. Thomas,
Yes, sir.
let me just ask, so you have the applicant you're representing does what for a living?
No, they're retired. They're elderly, but he has a background in masonry, a mason.
right.
So stonework and things of that. They're,
But to the level of being a contractor or just working?
no,
as a mason?
no, just as a hobby, but is knowledgeable in it. He doesn't. So I'll be able to explain just in a moment here. This is in 2014 what the property looked like, and you can see the house next door, and they're all relatively, the height of the roofs is the same, and you can see here there's numerous stairs going up to get to their front door. And if I can, Tammy, if I can have you help me get to the 2020 picture. You can see here, this is what what is there now, because it's been stopped, they did take that out. And there, if you look on the map, 2 cars can go in there, one where the truck is and the other one's behind this wall on the left, right there. And this entrance, which is now the basement, is reduced to 4 stairs getting in. And right now, if they go to the back of their house, it's 2 or 3 stairs to get into the main level. So they reduced their ability to, for themselves to climb stairs. And then ultimately their plan is to get one of those electric chair things that gets you up the railings. And if I can next have Sammy show you the 2019 picture. You can see here there's a grade. It's hard to see, but from 36 to 32, it's sloping down. As you get to 30 and further, the front lawns are basically level with the street. So my client just happened to be one that had a bit of a hill in the front, and they had no viable really place to park. In addition to, over the years, the increase in traffic and parking. And in my memo, I'd like to point to the case of Vine versus Zoning Board of Appeals for the town of North Branford, 281 Con 553, 559, 2007. In cases in which an extreme hardship has not been established, however, the reduction of a non-conforming use to a less offensive prohibited use may constitute an independent ground for granting a variance. And then it would, in that same case, the court further stated it would elevate form over substance to insist on the showing of an exceptional hardship when there is no claim or evidence that granting the variance could result in even minimal harm to the neighborhood or undermine in any way the overarching zoning scheme, especially when there is a substantial evidence to support a conclusion that will result in a more conforming use. And as we are right now, my clients, if you'd like them to, they can state on the record, as I'm saying, relaying for them now, that there's just an incredible increase in traffic there, especially around certain holidays and special functions that the boat club has, and this is a benefit to them and to the neighbors by getting 2 spots off the road and into their property. That of course, there's also going to be, if the board is willing to grant a variance, they would have to go back to the building department and continue on with other items with the various departments in the town. And I think that's it. Thank you.
Okay, then you're willing to answer questions from the board, I would take it.
Yes, of course.
All right,
Well-
with that in mind, the first and most obvious question is, how many permits were taken out to do this work?
Well, that's the problem. There weren't that.
Okay, let's move on, and any other board member that has a question, go ahead and
I'm
ask.
sorry, Mr. Chairman, my clients are here. You took out 1 permit?
Before the excavating started, the
Yeah.
first permit was to redo the sewer main. So we dug out a lot of land to get to the sewer main.
Okay,
And then-
I apologize, I
and then-
misspoke.
That was the
I
last permit
misspoke.
taken.
There was a sewer main break, if you will, and they took out 1 permit to remove that sewer break. And because they had to do that, that prompted them to think, oh, maybe we can do this now and remove it, because they were already removing earth.
Yep,
So there was
got it.
1 permit that was pulled for the excavation for the sewer.
Right. So the permit was to repair the sewer.
Yes,
Just
Right.
completely replacing the house history.
Understood.
yep, thank you.
Do we have other questions from other members of the board?
Yes. Do you have an architect or engineer that will certify that the foundation of the house and the retaining walls are sufficient to support what was built without permits?
What was built with, nothing was built. that's all existing.
No, when you excavate down, you had to put a foundation in at least 42 inches below grade.
Oh,
Well,
did
you've
they-
reduced grade.
Oh, okay.
Do you have an engineer
Can-
or architect that is ready to certify what they built without the permits?
Yes, that's been done. My clients are here and they said to me the 42 number was exactly
No,
what.
I don't want it from them. Do you have an architect or engineer that will certify it?
Yes, I can get an architect and engineer.
So
to
you
certify.
don't currently have anybody?
Right now with me, no, sir.
Okay, that's question number one.
Yes,
The first floor of the house use has not changed, presumably. It still probably has a kitchen, dining room, and living room, correct?
that is correct.
Okay, by excavating down, you really have not changed the number of stairs that must be climbed from grade at the front of the house to the first floor. Now, you claim that your owner is going to install a stair lift.
Well, the rear of the land slopes down. So as they get to the back of the,
I'm not worried about the back of the property. I'm dealing with the front of the property.
there's no access to the first floor, if you will, from the front of the property. They walk through the basement.
So the number of stairs has not changed. Their ability to get from grade at the front of the residence to the first floor has not substantially changed.
That's
It's not a single
That's
staircase,
not
it's
the,
multiple.
no.
That's what I'm asking.
No, it's been reduced.
No, it's been increased. Is my substantiation.
Let me cut in on this debate. It sounds to me logically that it's the same. I mean, the number of stairs may have changed,
Yeah.
but the vertical height is the same.
Oh,
You
of the
either walk up
building.
the sidewalk
Of-
or you walk in and then go upstairs, one way or the other. I think
Thank
maybe
you, Andy.
Mr. Levy was leading to a second question, which is what use have you made of the basement?
It's open. There's been nothing in the basement, construction wise. It's just opening, putting the door there.
And you have a legal stair from the basement to the first floor.
It goes out the Bilco doors out the back. And then that's.
How do you get from the basement to the first floor?
Through those stairs, right? It's an enclosure. It's a room that goes, it's like a hallway. You go out the Bilco doors in the back and loop in through the back door.
Why do you have to go out the back door to get to the first floor of the house?
There's
Is
been
there no
construction
legal
yet.
staircase between the basement and the first floor inside the structure?
Are there any further stairs from the inside? Okay. They've been removed. So all the construction has been stopped.
Do you
Understood.
plan to put a legal stair in?
Yes, and that's where the electrical chair will go.
Okay, the elec-
We're getting ahead of where
Okay.
they're at. They're
I'm
not there.
just getting argumentative.
No, what's happened is that they've stopped. They've got a stop work order from the building
Yes, I
department.
understand.
So we don't have a permit and we don't have a plan and we don't have approval from architects and we don't have an engineer report. We got none of that.
Okay,
Danielle,
Right.
you were,
Yeah,
Go-
I'm seeing
go ahead.
proposed plans, but yeah, I don't think anything's signed or sealed. I mean, there's not even a name on them, but
exactly.
we can kind of see the intent, I guess, from these drawings.
And
Right.
this was just to get two spots on the street? Off the street? Is this how this all happened?
It snowballed into this. Yes, what led to the sewer pipe led to, oh, we can dig this out because it's only a little bit left. We can get two spots here. And then they saw the foundation and like, oh, this helps us get in here. And it snowballed into where we are now. And like I said, I've been retained to help them through the process now, but this is where we are now. And I think this is step one. This is simply, I guess, a variance on what's on the outside. That's
Yeah,
where the damage occurred, if you will. It's the exterior, the earth was moved, and that's what the variance, the regulations address. It's height and the 2 spots.
Yeah. Horses are
And-
certainly out of the
The-
barn on this one.
Wait a minute. Let's be
I was just
clear.
saying the horses are certainly out of the barn on this one, so it's,
There's two issues. One is parking,
Yes,
and that's a separate issue. Another issue is by uncovering the foundation walls of the walls of the basement, the regulation would then require this to be counted as a story.
right.
And
And
so
we
they
got it.
automatically go to 3.5 stories.
And yes, and we've got it to the point now where the regulation would allow a 3-foot, let me make sure I tell you the right, average grade at front of the building, basement to ceiling is 3.46, and the regulations allow 3.00, so it's 0.46 feet difference. So that would be what the variance would be for, the 4.6. The
Point
0.46, thank you.
Boy, there's an awful lot of stuff missing here. It's about my only
Viewers-
comment. I'm kind of awestruck like I was when I first ran into this.
Have you received permission from DPW for a curb cut yet?
I think it's the same one.
It's the same. We haven't gotten there yet, sir. We were just trying to get this because we
Okay.
also have pressure from, as Tammy has stated in her synopsis, that it's been in front of the citation board with a substantial fine, and they were giving us a deadline to be in front of you before we do anything else. So that's why we're also here.
Okay,
I think that amounts, prior to me getting involved, had ballooned up to $36,000 or something in that range, with the requirement that the last one that I was at get in front of the zoning board of appeals. So we're here to kind of put that fire out, and hopefully we can move forward here.
I see a public safety requirement, which is that we know that the building is safe. And where you're at right now, we can't possibly know that.
Okay. I mean, I'll be more than happy if the board will allow me to continue this, to provide you certified plans and get a survey, the engineer in to certify that it's all done correctly and done right. Be happy to submit that to you for proof of safety.
I'm fine with giving a continuation if we can legally do so. Tammy, where are we at on terms of total time expired?
These are just before you. This is opening of public hearing. So this is their first official night.
All right. Let me just comment. I'm fine with that. I don't know how the other members feel until we poll them. I particularly think it's too egregious. It's asking for too much. And I think you got to go back and fill in at least part of what was excavated. I could see putting parking there, and I could see an entrance into the bottom, but you can also go back and cover a lot of that basement wall so that it looks nicer within the neighborhood setting. But that's just my opinion. I think at some point you need to marry permits and design and engineering with your application so that we have something substantial to deal with. Right now, this is totally insubstantial. Any other board member want to offer?
well, I'll voice the opinion that this is incredibly egregious, that anyone who thinks they can go ahead with a project of this magnitude without building and zoning permission, personally, I think we should deny this application in totality.
Okay, anyone else?
I agree with Andy that we should, look at some plans and that are certified, and that also, I think that, the design can change a little to be less egregious and not ask for so much. I mean, 0.46 feet, right? We're talking about like 6 inches. I think there are ways that this could come into greater conformance with the zoning code.
Anyone else?
Yeah.
How do we feel, about continuation, since I'm okay with it, Lee may not be, anybody else?
I'm okay with it if they can produce an engineer and architect, someone to come through with them to at least substantiate what they haven't done to this point. But this is a classic case of asking for forgiveness instead of permission. Classic.
I think you're right, but it's also somewhat dangerous in that we don't know how solid the structure is. Once you uncover the basement wall, you're asking for trouble.
Well, could there
Marilyn,
be
you had
is it,
yeah,
as you
this-
say, as a public safety, should there be a recommendation to have a building inspector go out there toot sweet
Yeah.
and check it out?
Absolutely, absolutely. Marilyn?
Yeah, I mean, I'm listening to this. I do think it's egregious, but also I just want to make sure, maybe for you, Andy, I mean, there's several things that need to be done here. Could you, if we put this off, if we postpone, what things need to be done so that we don't go through this again? And I have to say, yeah, a permission should have, I'm surprised that it got this far without coming before us. So just to make
Well-
sure, I mean, everything seems to be a surprise, and that's surprising to me.
I'm not buying the surprise. With respect to what's needed is excavation permit, and then the engineering, which would expose the basement wall. With the basement wall exposed, you need an engineer to say that the building will be stable. And more than likely, they're not going to do that. They're going to say you need to strengthen it in XYZ method.
Mhm.
And they could reduce some of that by simply putting fill back against the basement wall. Maybe. I'm not an engineer, so maybe I'm wrong, but I think that might possibly be part of the solution.
I apologize, sir, if I may, that has occurred already. It's not the basement wall anymore. There's been fill and wall has been put there already.
Let's
But
get
it
somebody
needs
who's
to be
expert out to look at it.
certified by
Yes.
an engineer.
Yes, sir.
We need, well, the safety part first. We need the building department out there looking at it, and we need an excavation permit granted. Then you can say, I want to make the alterations in the following manner, blah, 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 blah. And then you say, well, that will require variances. Well, we'll have a plan, we'll have an engineer's report. Whether or not we need an architect, I'm not sure, but we definitely need the engineer's report. And then you come and ask for the variances as a result of what those things reveal. We're just not anywhere near there. So I think coming back repeatedly is probably not a real good idea, because eventually you're just going to end up being denied. So somebody's got to get their ducks in a row here, and they definitely aren't in a row tonight.
So Andy, can I just ask so I can make my notes? So you're asking for sealed architectural plans and an engineer certification.
Well, we definitely are looking for the engineer certification, but I think we also asked the building department to go out and take a quick look at it and make sure it's safe.
They've been out there. They're the ones who flagged this property, but what they would require is an engineer certification. So.
All right, let's get that.
I think not only on the house, but on the retaining walls that were built.
Yeah, how deep were they put down?
The retaining walls
Yep.
They were done
to 42.
it was all poured concrete,
It was all poured concrete, is
all
my point,
5H rebar, it was all.
with
Yeah,
rebar.
and to what, you say 42 inches depth?
Yes, with rebar.
Needs to be certified.
Yes, yes.
Okay, with that, Tom, Danielle, Marilyn, Lee, do you feel that it's okay to go ahead and grant the continuance?
I do.
Yeah, I think so. You have to. Well, you don't have to do anything, but yeah, I would.
Okay,
Yeah.
I do as well, but I think I'm only going to do this once. So next time back, you got to have it together.
Yes, sir. So we'll have the engineer's report. I'll reach out to Tammy as well. Which
This is
we
an
have.
administrative, let me just clarify the vote on this. This is an administrative matter. So that 4-to-1 rule doesn't apply. 3-2 would work. But we do have 4 in favor. So yes, the item is continued.
Thank you, sir.
So the next meeting will be August 18th.
August 18th. Thank you, Tammy.
Do you
And
want to
I'll-
do it then, or you want to wait an additional 30 days?
Is that allowed? I think it might be best so I'm not under pressure with any engineer's timeframe.
You know, you need enough time to get it done.
Yes. May I request until the September meeting?
It's
I
fine
would
with
be
us,
agreeable
but
to
Tammy, just the clock runs. That we can pull it off in September as well?
We have got 65 days to close the public hearing and then another, but I think he can ask for,
I think I can also grant a continuance on an addition. I can consent to one, I think.
Okay, yeah, I think we'll be okay, but we may
All right,
be,
let's do it then, September.
Thank you.
Okay. Next item,
Okay, item 22-0721-01, Mark Seaman. Special exception to separate 2 adjoining lots merged per section 118-800E2 in a residence zone. Property located at 197 and 199 Newtown Avenue, District 5, Block 20, lots 2 and 82. Request, the applicant seeks special exception to unmerged lots that have been combined due to same ownership and what is currently a non-conforming access way to the rear lot. Background, the subdivision was created in 1963. Lot designated as 119 Newtown has remained vacant. There is a single-family dwelling on lot designated as 197 Newtown. Analysis and findings. Lot 199 was created as a rear lot in 1963 as part of a 3-lot subdivision. The subdivision approval was approved by the Planning Commission and filed with the town clerk in 1963. It is not necessary to demonstrate zoning hardship for special exceptions. The only nonconformity of this rear lot is the access way at 15 feet versus the current 25-foot requirement. The history seems to indicate this was a lot that was intended to be built upon at some point. Mr. Chairman.
who's speaking for the applicant? Madam, go ahead.
Thank you, Mr. Chairman, and members of the Zoning Board of Appeals. For the record again, my name is Liz Suchy. I'm a partner at Carmody, Torrance, Sandak, and Hennessy, 1055 Washington Boulevard in Stamford. And I represent the owner and applicant, Mark Seaman, who is present for tonight's meeting, who may speak, who may address you, or who has, if you have any questions that I can't answer, he'd be able to answer them. By way of background and just for housekeeping purposes, neighbors were notified of tonight's hearing on July 8th by certified mail return receipt requested, as well as regular mail. And the domestic green cards, return receipt cards, were returned to staff this morning and should be part of your official file. As indicated in the memorandum that was just read into the record, the property is owned by Mark Seaman. The properties are 197 and 199 Newtown Avenue, District 5, Block 20, lots 2 and 82. It's in an A as an Andy resident zone. Tammy, if you would be kind enough to show the map from 1963, the original subdivision map. As she is doing that, as the memo indicated, the lots were created by subdivision in 1963 by the Planning Commission and also approved by the Common Council, which agency was in the 60s also required to approve subdivisions. It was then recorded on the map was recorded in April of 1963 and assigned map 6164. And the subdivision map is in front of you. You will see that it is 3 parcels, A, B, and C. The parcels that are the subject of this application, one is highlighted in yellow. That's property 197 Newtown Avenue, and that is tax lot 2. And the other parcel is 199 Newtown Avenue, highlighted in pinkish, purplish, and that is 199 Newtown Avenue. 197 plot B is developed with a single family house that was constructed around 1922. It's about 2,500 square feet in size, and that lot is 0.53 acres. The vacant lot, lot 199, is approximately 0.875 acres. And as you will note, there is a 15-foot access way identified on map 6164, which was the required access dimension when the lot was created in 1963. So why are we here? As mentioned in the memo, section 118-800E2 of the zoning regulation states that should parcels be in common ownership and one or more of the parcels do not comply with the regulations, then they are deemed merged by operation of zoning. In this instance, the lot that does not comply is plot A, or 199 Newtown Avenue, because it does not have the requisite 25-foot access, but a 15-foot access, which was the access way dimension required in 1963. So according to zoning, the lots have merged. So all that is before you this evening is the request that you acknowledge these 2 lots as separate valid building lots and grant the special exception to unmerged lots that have been merged by operation of zoning. There's no development proposal before you at this time, and should these lots be unmerged, any development of plot A, or 199 Newtown Avenue, would need to go through the requisite boards and commissions that would be applicable to and have jurisdiction over that development, one of which is the Conservation Commission, since the property abuts a pond and has wetland upland review area extending onto it. So certainly any development of plot A would need to be reviewed and hopefully approved by the Conservation Commission. And interestingly, I note to you that that is exactly what happened in 2011. This plot A did in fact secure an approval from the Conservation Commission for development of that plot. So my client is before you seeking your approval and your acknowledgement of the 2 separate and distinct status of both lots, plot B and plot A. This is not a variance, as was mentioned in the memo, so there is no hardship that you must apply and we must demonstrate to you. Rather, we must sufficiently demonstrate that the applicant had no intent to merge the lots. So you might ask, how do we do that? Well, that's done by documentary evidence and physical evidence. And as the application documents that I'm sure you received from staff, they're rather voluminous. It represents all of the documents on file for these 2 plots, which we believe substantially demonstrate that these lots were always intended to be separate. Without going through each and every document, I'll just name them, and I think it will demonstrate to you that the lots have always been separate. Clearly, they are identified separately on a subdivision map properly recorded on the land records. They have separate tax parcels, separate street addresses, separate property tax cards. They are identified in separate deeds. One is volume 7478 at page 84, and the other is volume 7477 at page 110. There are separate sewer tax bills. And as I mentioned before, there was actually an application filed and approved by the Conservation Commission for the development of 199 Newtown Avenue in 2011. For all of these reasons and all of the documents that have been submitted to you, we believe that the evidence clearly shows that the lots are separate and there has not been an intent to merge the lots into one large lot. So we ask that you grant the special exception application and allow us to move forward, allow my client to move forward either with a sale of plot A, 199 Newtown, or his own development of plot A, 199 Newtown. That's kind of the long and short of it. As I said before, there's no hardship standard that needs to be submitted to you or described. I think the documents do speak for themselves in connection with this request.
Does the board have any questions?
Done
Hearing
with
none.
me.
Hearing none. Tammy, do we have any raised hands out there, or if anybody might want to speak in support?
We do. We also, just so I don't forget, we also have 3 letters of opposition, but I'll do the attendees.
Let me just check with Lee. Lee, do you happen to have those?
No, I don't. Not as part of my package.
Well, they were emailed. I
I
didn't
did
see
not
them.
see them.
So that leaves us with Tammy having to read them.
Thank you, Tammy. I apologize.
All right, so I'll read before we let the attendees call in, or is that how you want to do it?
I think, well, it's the same process. Who is supporting it, either via mail, email, or a speech?
Oh, right. So these are actually opposition. So I'm not sure if any of the callers are in support.
Yeah,
Just me.
support first, opposition second.
Okay, so if you,
I got my hand up.
I think Mr. Seaman would like to speak.
yep, you can speak.
Oh, okay. Thank you. I didn't know if you guys could hear me.
We can,
Thank you very much for hearing the matter. I must admit, it kind of started with me as a surprise. When I bought this back in 2011, right? Everything in the records, public record, everything the lawyers looked at, the title searches, the banks, everybody had this as 2. I bought it kind of to be 2 lots with the intent of someone down the road at retirement, right? That was kind of going to be one of the nest eggs that became the payoff of the mortgage on the other piece when I was done. And we only just came to this because now that I'm getting close to that, kind of 3 to 5 years out, I started digging back through paperwork and said, let's get everything kind of set before we know what's in front of us. And lo and behold, I found out that I didn't have 2 lots anymore. So it kind of came as a shocker to me. The other piece is when I did get it, the other bidder on this was a developer doing it. That's why all those plans were filed. And when I took it over, it was kind of grass up to your elbows and hips. And I probably took out 2 dumpsters worth of construction and lawn debris when I came in. And it's just been left the way it is ever since. So I don't think I'm asking for anything new that didn't exist. I think I'm looking for going back to what I thought was always the status quo.
okay. Thank you. Do we have anybody else that was going to speak in favor?
There are no other hands raised.
Okay, anybody opposing? You said we had letters that are in opposition?
Yes. Okay, we have a letter from Oksana Klein. She says, thank you for sharing these documents. We wanted to express our concerns regarding the potential reseparation of these 2 properties, as our property is located directly behind 199 Newtown Avenue, where our view is centered completely on the pond that is on 199 Newtown. A large part of our property value hinges on the unobstructed spectacular pond waterfront view that we have. Our concern is if this property is separated again, that it will be eventually sold to a builder, as there is no current structure. A house could be erected directly obstructing our view, significantly diminishing our property value. Our property value and the Cranberry area, Stony Brook Road, Norwalk in general have greatly benefited from recent property value increases due to the rise of demand in home buying over the last 2 years. We know that if this plot is available to build on, our value will deflate. We have consulted with our original realtor, who agreed that this would be devastating for us if we were to sell after a new build on 199 Newtown Avenue. With a toddler and baby on the way, next week, we will outgrow this home in the next several years and will need to look elsewhere. We are hoping that by that time, we will not need to worry about selling for less than we purchased due to a new dwelling blocking our view. Additionally, the devaluation of 5 Stony Brook Road would also likely reduce the property value of other homes on this street and in this neighborhood that have been rising over the last several years. Please see attached of our view from our backyard on 5 Stony Brook Road to 199 Newtown Avenue. We appreciate your time in reviewing our concerns, and to the city of Norwalk for allowing us voice our thoughts in this matter. Thank you, Kevin and Oksana Klein. And if you bear with me, I'll be able to call up the photo.
Tammy, if you need me to read the next one, I could.
Oh, you have them? Yes, good.
I do.
All right, let me find this photo.
I have that as well. I have the photo as well. I just don't know if it's so easy for me to, there you go.
There we go.
Yeah.
So you'll have to turn your head, sorry.
Mhm.
Maybe I can. That's the best I can do, guys, sorry.
Right, and Tammy, I can read the third letter. We'll make it like Passover.
Perfect.
Yeah.
So you can see the pond, looks like some waterfowl.
Yeah.
We seen enough of that?
You want me to do the second letter?
Please.
Okay, so this is from a Michael and Nancy Butts at 7 Stony Brook Road, Norwalk. In regards to the separation of 197, 199 Newton Avenue into two valid legal separate lots, with 199 Newton Avenue to be designated as the future building lot, we are opposed to this separation. We are the property owners of 7 Stony Brook Road, 1963 surveyor map, William and Jean Hoyt owners. Our property abuts the majority of the lower end of the vacant lot and aligns with the larger portion of said building lot as stated in the 1963 surveyor map. For 44 years, we have enjoyed the unobstructed view of the pond and abundant wildlife on the lot, including baby deer, coyote pups, egrets, hawks, osprey, and the occasional turkey. However, our main concern regarding the development of this lot is flooding to our property. The land at 199 Newton Avenue is a higher grade than ours along the entire property line, and runoff always goes to the lowest level. Any construction, i.e. removal of trees, rocks, and soil, will certainly disrupt the current flow of water/drainage, causing an issue for us. A brook runs through the other side of our property and has overflowed numerous times with heavy rains, resulting in 50 feet of our property being underwater. The lot at 199 Newton Avenue has not experienced this flooding in the lower corner due to the large pile of yard debris, tree limbs, branches, leaves, etc., that has been built up the last several years. This makes the ground higher than ours and works as a dam that prevents proper drainage. On the corner of this lot, where the brook drains into the pond, you can see bank erosion from flooding. Several years ago, when we did an addition, the permit required that we the permit required that we install a silt fence at the top of our property to prevent runoff. We are approximately 200 feet from the water, so runoff was a concern. We are opposed to a separation of these two lots, whether it be for current or future use as a building lot. We know for certain it will devalue our house and property and is a major cause of concern for future property damage to our land. Sincerely, Michael and Nancy Butts.
So should I read the third letter?
Yeah, well, that's the end of the second. Yes.
Okay. Okay, so this is from Marion and Carlos Costa. This is 3 Stony Brook Road. Hi, Tammy. We are writing you in response to a recent mailing we received regarding an application for special exemption for 197 and 199 Newton Avenue, Norwalk, Connecticut. Mark Seaman, owner. Our property, 3 Stony Brook Road, abuts the proposed access way for the lot that is vacant, lot 82. The concerns and questions are as follows. 1, the proposed access way seemed to be right up to our property line and across the entire back end of our yard. We would like to know if there are setback rules for this proposed access way. Number 2, another concern is environmental, as there's a large water source pond located on lot 82. The pond is home to wildlife in the area. Just yesterday, I took a picture of a huge turtle making its way across our backyard. Construction on this lot undoubtedly would disrupt this habitat. We know that there is a 40-foot setback from property lines for construction of a new structure. But what are the setback rules for wetlands and or water courses? The land survey that we saw is almost 60 years old, 326/63, and not to scale. Number 3, if this lot becomes a separate buildable parcel, we fear a devaluation of our property would happen. Thank you in advance for allowing us to voice our concern and comments. We would also like to be included on the Zoom meeting scheduled for tonight. Best regards, Marion and Carlos Costa, 3 Stony Brook Road, Norwalk.
And I'll just say one more time there's one phone-in caller remaining. If you wish to speak for this item, it's *9 to raise your hand and then *6 to unmute yourself. Not raising their hand. Andy, you need to, yeah, thank you.
No hand raised.
No hand.
No hand raise.
Okay. There isn't any need that I see to contradict any statements made, but if you wish to, Ms. Suchi, do you want to add anything on? Go ahead.
Yes, I would. My first question though is, do any of you have any other questions of me or what the documents we've submitted or the history of the parcel and its creation?
Liz, will this have to go back to the Conservation Commission, given the amount of time that's lapsed?
That's an excellent question, Mr. Levy, and I'll get to that I can answer that one first. Sure. The permit that was issued by the Conservation Commission in 2011 is no longer valid. So any development of this lot, should you deem them to be separate lots, would require a new application to that agency. That's the first issue. Second issue is there is a 50-foot upland review area that extends from a wetland and a 100-foot upland review area that extends from a watercourse. If this property were to be separated out and development proposed, then a new survey would have to be undertaken and with a new soils report to identify whether there is just a wetland or if there is a wetland and a watercourse. And then the associated upland review areas would have to be noted on that survey. So that's one limiting factor as to where development could take place, just the upland review area and then the Conservation Commission's evaluation of activity that would be proposed either in or near that upland review area. Second of all, a rear lot in today and in 2011, when that approval was originally granted, under the zoning regulations, a rear lot must have a 40-foot setback on all sides, a building setback. So development in that rear flag lot needs to have a 40-foot setback on all sides. The access way remains at 15 feet, but there is no setback for the access way unless, of course, a structure is placed on it, but it would be limited to access. So those are two instances in which there is additional review and evaluation of a proposed development of this lot when and if it should come before any board or agency. One comment that was raised is the view right. Well, there is no right to a view in Connecticut, and that has been consistently upheld by the courts, unless, of course, it is in an express easement or restrictive covenant, neither of which apply to this lot. And those standards have been articulated in Robinson versus Clapp in 1896 case, and most recently Bosey versus Hampton, a 1999 Superior Court case. I appreciate the comments from the neighbors. Mrs. Butts was a neighbor when the 2011 Conservation Commission approval was granted. And to the best of my knowledge, she did not appeal that approval. But even so, the conservation issues, development issues, environmental issues, and impact on property values are not considerations before you this evening. Yours is a very narrow focus of simply determining whether or not we have established that there has never been a right to an intent to merge the properties. And as I said earlier, I think the documentary and physical evidence clearly support that position. Other issues such as runoff, that would be something that would need to be designed by a civil engineer in connection with any application to the Conservation Commission to confirm that runoff would not impact adjoining properties. And as I said before, environmental, wildlife, drainage, wetlands, those are all issues that the Conservation Commission would be charged with evaluating for future development purposes. I think that answers most of the questions that the neighbors had raised and addresses some of their comments. At this point, I have nothing further to add unless you have questions of me or my client, Mr. Seaman.
I don't hear any. So let's, we've gone out and asked for positive and negative comments on this, and we have read the letters, and no one has subsequently, somewhat lately, shown a hand raised. Is that correct? Tammy, you're muted, by the way.
Yeah, sorry, that's correct. Yeah, no additional hand raises.
All right. Anybody on the board have any final question?
Not from me.
All right, so let's move on. Thank you, Ms. Suchi.
Thank you.
Okay. Item 22-0721-02, 10 Van Tassel Court LLC. Proposed motor vehicle repair application in a business zone number 2, property located at 8 Van Tassel Court, District 1, Block 105, Lot 25. Request: the applicant seeks approval from the board for the K7 license to operate a motor vehicle repair shop. There is no proposal for sales of vehicles. Background: the subject parcel is located in business number 2 zone. The existing commercial building was constructed in 1946. It includes overhead garage door access at the front facade. Analysis and findings: motor vehicle repair appears to be consistent with the nature of the building and its location. State statute requires that the Zoning Board of Appeals review motor vehicle repair and sales applications. In this capacity, the board acts as agent of the state to decide whether this is an appropriate use. In granting the license, you are affirming this is an appropriate use. Should the board approve the K7, the applicant must still seek approval for special permit by the Planning and Zoning Commission per Norwalk zoning regulations. Mr. Chairman.
Who's speaking for the applicant? Oh, Ms. Suchi, I'm surprised.
I guess the phrase tonight is third time's a charm. I don't know. So thank you again for your attention this evening. Liz Suchi of Carmody, Torrance, Sandak, and Hennessy, 1055 Washington Boulevard in Stamford. And I represent the applicant, Andrea's Restoration LLC. Attending tonight's meeting is Andre Crump, who is a principal at Andre's Restoration LLC. His mom and advisor, Jacqueline Fuller, and also Wayne Devanzo, the project civil engineer, should you have any questions of any of them. The neighbors have been notified of tonight's hearing by certified mail, return receipt requested, and regular mail on July 8th, and those green cards have been returned to staff and should be part of the permanent official file. The property is at 8 Van Tassel Court, District 1, Block 105, Lot 25. It's business number 2 zone. Tammy, if you wouldn't mind, if you could call up the site plan by Mr. Devanzo, that would be helpful, or the survey actually, while I'm going through this. The lot is about 6,400 square feet. It is bounded to the west by Metro North Railroad, to the south by other commercially developed properties, to the north by other commercially developed properties, and the same to the east. Some of the businesses on Van Tassel Court include Kaiser Battistone Sewer and Septic, Fahey Plumbing, Silvermine Printing, and A&A Landscaping. They're all down at the end of Van Tassel. And for those who've not had the opportunity to view the site, if you travel northbound on Main Avenue, you make a left at Van Tassel, which is the street just before the dry dock. You go all the way down to the end of that road. You'll come to a cul-de-sac. This property, this structure is on the right of that cul-de-sac. It's that hash mark building, kind of oddly shaped boot that Tammy is describing right there. The building is about 5,400 square feet. The southern 1,600 square feet of it is occupied by the owner of the property for warehouse and office purposes. And that owner is John Romano, recently deceased John Romano, a longtime and well-known Republican leader and chairman of the Harbor Management Commission, who we just lost just within the past week. My client proposes to use the northern 3,800 square feet of the building that Tammy was circling for a motor vehicle repair facility. Light repairs, including painting and other typical repairs that would be done. All work would be proposed to be done inside the building. There wouldn't be work taking place on vehicles on the outside, but the vehicles would be parked on some of the numbered parking spaces that are shown to the right of the screen. And that right of the screen abuts the Metro North railroad tracks. So there aren't any residences to the west, to the north, or to the south of this parcel. Ms. Maldonado, if you wouldn't mind sharing a few of the photos, and I'll go through the rest of the application. My client has no intent to try to get on the city's tow list. There will be no sale of motor vehicles from the property. And as I mentioned before, all motor vehicle work will be undertaken within the structure. Generally, hours of operation are Monday through Friday from 8:30 to 5, Saturdays from 8:30 to 1. But if customers need work done and he's busy enough, God willing, those hours on Saturday may extend to 5 p.m. or so. It's anticipated that Mr. Crump will have one employee. So this is a gentleman who has started his career in the automotive restoration business as an employee and at Blackbridge Motors on Wilson Avenue. And now he would like to go out on his own and start his own business here in Norwalk. As was indicated in the memorandum, you sit as an agent of the state of Connecticut Department of Motor Vehicles. This is not a variance, so there's no hardship standard that need to be applied. These very limited standards in the zoning code are strictly, is this use closer than 200 feet to a church, a school, a hospital, theater, or public library. Beyond that, there aren't any other standards of review for your decision-making purposes tonight, and nor are there any state statutes that give any greater standards of review when you act upon a motor vehicle application, such as the one before you this evening. That's really about it. If you'd like to see the site plan by Mr. Devanza, we can certainly call that up. One of the things that we've suggested, and clearly this will be reviewed by the zoning commission in connection with the special permit application, is landscaping. And we've suggested 2 street trees along the front of the building or at the south of the building around the cul-de-sac to kind of soften the building and give it a little bit more green space. And no changes to the building, no second floor, no additions. There'll be some upgrades, probably just exterior painting. And that's about it. Vehicles will come down Van Tassel Court, come into the paved asphalt area that you see. And as they're ready to go into the building for service, they'll enter the building on the overhead doors that are on the northern corner of the building where it shows that 30-foot dimension. There's an overhead door there. At this point, I have nothing else to add unless you have questions of me or my clients or Mr. Devanza.
No questions.
Do we have any
for me.
questions from the board?
No.
This is something that the board has only recently been involved in. Tammy, is there anything special we need to know in this case?
No, this seems routine to me. I mean, they will have to make an application to the Planning and Zoning Commission because our regulations require it.
Okay. Questions to Liz, in case I missed you, let me know right now. Since I'm going to move this along, we're almost at 9:30. Do we have anybody that wants to speak in support of this?
There are no raised hands.
All right, anybody who's speaking in opposition to the application?
No raised hands.
All right.
And
So
no
with that in
comment.
mind, somebody wanted to comment or what? I'm just going to move us along a little quickly. here.
I'll make a motion that we approve this application as submitted.
A second?
I'll second that.
Okay, who is the second? Marilyn?
Yes.
Okay.
Yeah.
So Lee, Marilyn, all in favor?
Aye.
I,
So we're unanimous? All right, we are unanimous, no abstention.
Thank you for your time and attention this evening.
All right. Thank you, Ms. Suchi. Okay, working ourselves backwards. We have the property separation 197, 199 Newtown Avenue. Discussion?
Well, it appears to me that
no,
this has always been separate lots. And while we were offered no explanation as to how and why they became joined at the hip, shall I say, I feel that Mr. Seaman has the right to use this as a separate building lot, either for his own purposes or for sale, and that unfortunately, the neighbors have no right to a continued view, as we heard from in the letter. So that's my take on this.
To our knowledge, there's no deed restriction. So with that in mind, is there someone who wants to make a motion?
I'll make a motion to approve it.
All right, Tom?
I'll
Bart,
second it.
And Lee Levy. All in favor?
Aye.
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 Thank you all.
And the next item up, by the way, I just want to make a quick comment on the item. I can appreciate someone enjoying a view, I mean, particularly where I live. But it's just the fact of life that if somebody owns a piece of property, they own that piece of property. And unless there's restrictions on it, deed restrictions or other easements, it's theirs to do with what they will within the bounds of the regulations. So we've had many people approach us saying it's lovely, it's wonderful, and not just in this example, but in others. That's great, buy it. Get together, put together the money and buy it.
Also, that there still is a process to go. Down
Now,
the
there
road,
would be
they
other
may hit a
things.
roadblock as to
that
whether or not they could be built on. The
could-
wetlands
Yeah,
or,
well,
yeah,
build on
so-
it or do whatever they want to do with it. But yeah, there's other things that could still impede that. But the idea that there's a right of somebody because they live next to the thing for 40 years, there is no right. And you can create a right by purchasing, then you own it. The next item is the Finos, the property at 34 Burritt Avenue, which I think we have dealt with.
Delayed. Postponed.
Do we have the date in September that would be?
We do. Give me just one.
Because we're going to continue, we should put the date that we're continuing it to. Just look at your calendar and pick the
Yep.
third Thursday.
Give me just one second. Yeah.
You want me to look at mine?
Is it the 15th?
The
That's
22nd.
that's a weird one if it is.
Yeah, hang on. I feel like it's the 21st, but let me double check.
So is
I
the
think it's
first of the month a
22,
Thursday?
but-
Yeah, it's 20, I think the 22nd.
I'll tell you for sure in just a second.
I mean, I'm sure we don't have a holiday issue here. So it must be the third Thursday. We could just look at our phones and figure this out.
It's actually
The
September 15th.
Yeah, the
The
first Thursday is
15th?
the first.
Yeah, the
Yes.
15th.
So the first of the month is a Thursday, huh?
Sorry.
Yep.
Okay, that's it. So it has been continued to September, date certain, the 15th meeting of the ZBA. And then item B, which was property at 8 and 10 Pulaski Street. I'm open to discussion.
Well, I have issues with it, but because I feel like somebody who's not part of this got away with something for quite a number of years, probably without paying property tax on it.
That seems
But-
to have happened an awful lot.
Yeah, my feeling is to approve it as a workforce housing unit, but require the owner to designate a second workforce housing unit within the complex and to develop both sites with recreational areas.
I agree. Sounds like zoning commission will also require that second unit when they go for special permit. So,
We could require it.
yeah.
Let's beat them to it and require it.
So I think they're probably better off with both units required rather than just being denied the application. So, and then we could get carried away in what we need for recreation, like turn the unit into recreation. So
Well, I was gonna
rather than
recommend-
Go down that road, why don't we just do that? Why don't we just require 2 units, workforce housing, and that for each building, there be a recreation area of approximately 500 square feet? He was like at 510, wasn't he?
Hmm.
Yes.
Can I interject? Do you have a requirement for, they have 10 two bedrooms, and if you grant the variance, they'll have 6 1-bedrooms. Do you want to designate a 1 or a 2-bedroom as that second workforce unit? Or do you care?
If this is a single that's being added, I think we should make it a single, which is the second one. That's my view, but what do you think?
I have no objection to a second 1-bedroom being
Yeah.
designated.
Yeah. Let them enjoy the 2-bedroom income.
All right, so we're moving down that road. We're saying 2 units, workforce housing designated, both single room or single bedroom.
Mhm.
And that we will in addition require recreation areas as had been described of at least 500 square feet. And I just want somebody to tell me they heard the same square foot number that I did, 510.
Yes.
Yes.
It was 510 on one building, and they were going to increase it on the second building. I think it was 20 by 10 on the second building, but they said it would increase that from there.
Yeah, so let's just require at a minimum 500. That way we've got beyond what is required at each building, and then they can figure out how to do it. I hate to be overbearing in applying these things, but if we can just get the recreation areas in place, I think we're doing something good. Anybody have a problem with that?
No?
No? All right, so let me stick my neck out and I'll make the motion that we approve it, and that a condition is that we require 2 workforce housing units, each unit being a single bedroom unit, and that in addition, there be a recreation area designated at each building for a total of 2 recreation areas at a minimum of 500 square foot each.
I'll second that.
Anybody have anything to add, subtract? No? Okay, so all in favor?
Aye.
Aye.
Aye. Anybody against? No, we're unanimous. Terrific. I like unanimity. So, next up, I wasn't around for, the meeting last time. I was in Mario, Scotland, and, having fun with COVID. My wife and I both got it while we were there. So that kind of dented the 1 month a bit, unfortunately. And during that time, you guys met, and I guess you only had 4, so some of the stuff got continued, some didn't, I don't know. But you want to go over the minutes and approve them?
Well, I went through the minutes. I really have no objection to what we received.
We missed, weren't we gonna
We
vote on
forgot one.
Sedita family, 8 Yarmouth?
We can,
Oh,
oh, yeah,
Andy.
yeah, right, yeah.
Which was a.
Yeah, we'll do that. Let me just get the minutes out of the way and we'll go back and finish the CETA. I kind of have it in my head that we already did that, but all right, go ahead. Just call it long COVID.
I make a motion, we approve the minutes of the July,
Was June.
the June meeting of the zoning board of appeals.
I'll
Second,
second it.
So I'm abstaining. Anybody else?
I'm abstaining because I wasn't here either.
Okay. So all in favor of who can vote?
Aye.
aye,
Aye.
All right, the minutes are passed. With the folks that have property at Yarmouth Road within Rowayton down at Bell Island, I think they did pretty much what we asked them to do. Anybody else have a thought on this?
Well, I would have preferred the parallel parking spaces, but I am satisfied that they met the goals that we set.
Yeah, I
There's
think they
nothing-
did.
yeah, they're gonna need a shoehorn to get those cars in and out. It's so tight up there, but
So well.
Yeah.
whatever.
I think they did a good job. I mean, it's crowded down there. Everyone that's down there knows that, and I think that they're complying. And also importantly, the people around them, the neighborhood seems to be very in favor of it because they have no place to park.
I only thought parallel would work better for them. But I do think that creates more visible car by having 2 cars nose to tail along the very edge of that alleyway or road, I guess. And by putting them in tucked in, there's less car visible, particularly if you have the shading by whatever the heck they were going to plant in that 1 or 2 foot space between that and the sidewalk. So I think it's a reasonably good solution, if difficult to use. So with that in mind, all in favor?
Somebody has
Aye.
to make a motion.
Yeah. Oh, gotta make a motion.
That was it, to approve it as
Oh.
they presented.
Okay.
I'll second
Anybody
it.
second?
I approve that.
I'll do that.
Tom seconds,
Yes, sir.
and we approved it, and they're done, we're done. So you've got the spaces approved, Liz.
Thank you, everyone. Have a nice weekend. Stay cool.
Ready?
Okay,
Thank
too.
you.
3 for 3.
So Mr. Long COVID here is going to ask you guys to move things along quickly. Do we have any other administrative stuff that we have to take care of? I know that we have 1 resignation from the board, which I expected. So if you have somebody that you think would make a good board prospect, might forward their
Who
name.
has resigned?
Who's not here? It's one of those two.
Okay,
Chris?
I'll assume it's Chris.
So, and also, if you're an alternate and you have an interest in the near future of becoming a regular member, let us know that too. And the only difference is that I do need regular members to show up. Now, you guys have been showing up anyway as alternates, even though you're more obliged as a regular member to appear. So once again, if you have somebody that you think would make a good candidate, the main thing they need to know is that we do not plan, we do not regulate. We're not a zoning board. We're not a planning board. Basically, we're administrative judges. And fairness is part of it, but we also try to stay true to the zoning regulations. And we try to make sure that through the mechanisms of approvals and administration that we don't deny somebody rights to their property. All right, with that in mind, anybody have something that they want to discuss briefly? Gotta be very brief though.
It's like just one question. Are we supposed to get training somewhere down the road? I know there's a backlog.
Yeah, that's why I've had it added to the menu. There's a little debate internally about whether we should start right now or wait as we go along. I favor not waiting, and some of the folks internal to the organization favor waiting. I think because of the new law, that there's going to be more demand, and because the resource in the past proved to be not much, that we should go for it and grab it as soon as we can get our hands on it. It would be wonderful if one or two of the universities that were involved in this before, or in organizations actually, that they would have something online that we could teach ourselves and then qualify for, and maybe with a brief online session in a group environment. I learned a lot in the training I went to, and I would recommend it for anybody, even if you think you know a lot. And I'm an egotist, so I thought I knew a lot. I found out that's not true. I did not know a lot.
All right.
Well, I think we should move ahead on training as soon as possible.
Mhm.
I agree with that.
Yeah,
would
I do
like-
too.
There's always
But Tammy-
something to learn.
Take the word back to the on high hill that training is something we need to pursue.
I'll do my best.
All right, and you might give the mayor's office a call and say, that third alternate, we need them now. And if y'all have a suggestion, forward it in to Tammy and myself, and then we'll go from there.
Is it unreasonable to say no one gets to take a vacation?
What vacation? Who said vacation?
I had one in February.
Not anymore.
What we need is that third alternate real quick. And then if we can settle that down, then we can work on filling in the open regular board member position. And I'd like to get that done within the next month, if not that, 2 months max. And if either of the alternates is interested in becoming a regular member, let me know.
Make a motion, we adjourn this meeting.
Any seconds?
I'll second that.
Tom seconded. All in favor? Aye.
Yes.
Aye. All right, thanks.
Okay.
Appreciate
Night.
you.
Thank you.
Everyone.
Good night now.
Good night.
Good night.
Bye-bye.
Bye-bye. Bye, Tam.
Bye.